Well, you know what? It's 12:07, so I'm going to get started because I definitely don't want to cut Rishi off short. I think all of the information he has is super important to all of us as business owners and employees and whatnot. So I'm going to do a quick introduction of Rishi, and then we will go ahead and turn the floor over to him. What I do ask is that he's got a lot of content, and more than likely, a lot of your questions will be answered as he goes through his presentation. So I'm going to ask that you hold on to your questions for the end of the presentation. But sometimes I know I get excited and I forget my questions. So we have the chat forum. So I'm going to encourage you to put your questions in the chat forum, and then we can address it at the end, or at the end, throw on your cameras. I know, as I said, it's so tough when you're doing a presentation and you're looking at a blank screen with no faces, no, communication expressions or whatever. It usually, it helps the speaker to relate to the audience. So I'm going to encourage everyone to turn on those cameras while the presentation is going on, or even at the end when we're doing the Q&A. At least we can see some smiling faces, and I'll have announcements at the end as well. And if you want to ask a question, the best way is to use the reactions button at the bottom of your screen and raise your hand, or just raise your hand, and one of us will select you, and we'll go from there. Alrighty. So Rishi Bandhu practices labor and employment law out of Oakville. Rishi is an 1998 graduate of high distinction from the University of Toronto, Trinity College. He received his LLB from Osgoode Hall in 2003, and he was called to the Ontario Bar in 2004. His practice since that time has been focused mainly on labor and employment matters exclusively. His experience and expertise ranges from labor relations, including labor arbitration proceedings and collective bargaining, to civil litigation of employment law disputes and workplace investigations. He advises and represents employers in human rights proceedings and matters before the Ontario Labor Relations Board. Rishi is frequently asked to speak at conferences and seminars and lead training seminars for lawyers and human resource professionals. Since 2018, Rishi has served as an instructor for the University of Toronto School of Continuing Education's Industrial Relations course, which caters to candidates for the Canadian Human Resources Professional designation. So without further ado, I am going to pass over the floor to you, Rishi, and thank you so much for taking the time and sharing your expertise with us.
Thanks so much, Sam. Thanks for that introduction. It's really a pleasure to meet you all, to connect with you, and to hopefully impart some information that might be helpful. I know it's a bit confusing with all the changes that we're seeing. More on that in a minute, but I just want to note as a disclaimer, unbeknownst to me, window cleaners have shown up at our office. I have 4 windows in front of me. They did the FAR 2, and they're very loud. They come in and they bang on it with their suction cups. Fortunately, it doesn't take very long, but I think today might be a very good test of my distractibility. But more importantly, if you do hear some noises, just bear with me. It'll be over in a couple of seconds. So back to the topic at hand. As Sam mentioned, I graduated from law school in 2003. Shockingly, next year it'll be 20 years. It just blows my mind. But I've always practiced in labor and employment law. So I started out with a large boutique firm that specialized in management, labor, and employment law. And then I worked for a series of boutiques before I went out on my own. And if you've been working since the early 2000s and managing employees, you'll no doubt agree with me that things have changed considerably. Legislation has changed, court decisions are changing, and I think what's at the heart of it is there's increasing recognition that the power imbalance between employers and employees needs to be rectified. And that's always been the struggle with employment relationships. At one point, when I started, it was very common to refer to the employment relationship as a master-servant relationship. And if you look at the textbooks, it's still characterized that way. And so inherent in that, you see that power imbalance, and that power imbalance tends to be abused, or at least our judges perceive that. And that has resulted in a number of changes over the years, whether it's being able to sue for human rights discrimination in courts, or increasing punitive damages or bad faith claims, or changes to the legislation, which we're going to talk about today. So we're really on a new frontier here, and there's so many changes coming out, and it's hard to keep track of. So I'm hopeful that today I'll be able to make sense of at least a few of those changes that have happened up until now, and some of the changes that are coming down the pike. So let me share my screen. So again, we're talking about recent employment law changes, but really focused on legislative changes. There's enough there certainly to talk about within half an hour, arguably more. So just a disclaimer, I'm not providing any legal advice. If you need legal advice, that's something that can only be provided through engagement of a solicitor, and explaining all the facts and circumstances of your unique situation to your solicitor. And at that point in time, advice can be given. So for the purposes of today, treat this as sort of general information. So a little more specifically about what we're going to talk about. Two changes in particular. One, Bill 27, which I'm sure you've heard of through the STAR or CP24, the Working for Workers Act 2021. Two major changes with that have caused a lot of confusion for employers and employees. Disconnecting from work. So we have to create that policy. What does that mean? Is this creating some new right? What do these policies have to look like? And by when do employers have to have these in place? And then secondly, the other major change with Bill 27 was non-compete agreements were banned. And so we'll explain, we'll talk about what that actually means in practice. More recently, in 2022, we had Bill 88, the Working for Workers Act 2022. And the major changes there were with respect to electronic monitoring policies and rights for digital platform workers. So your Uber drivers, Uber Eats, that sort of thing. So we'll talk a little bit about that. Let's start with Bill 27. So Bill 27 passed. It received royal assent on December 2nd, 2021. And the bill contains a number of changes to various statutes. Most importantly, the Employment Standards Act 2000, which sets the minimum standards for employment laws throughout the province. And then the Occupational Health and Safety Act, which sets out an employer's obligations with respect to ensuring safety in the workplace. So I'll touch a little bit on the Occupational Health and Safety Act changes. They were significant, but not as extensive as the ESA changes. So under the ESA, three major changes. One, this requirement for a disconnect from work policy, the banning of non-compete agreements, and the licensing of temporary help agencies and recruiters. So let's talk about disconnecting from work, which was causing a lot of confusion and a lot of controversy. So first of all, who does it apply to? So it doesn't apply to every employer. So if you have less than 25 employees on January 1st of any given year, the policy requirement does not apply to you. If you have more than 25 employees, then you have to create that policy. So it's going to apply to all employees. So you have to count everybody at all locations in the count, whether or not they're on a leave of absence, like pregnancy leave or parental leave or something like that. Temp agency employees are not counted, and it's applicable to all categories of employees. So from your line level employees or your retail employees all the way up to management staff, the policy applies to them. You must have a written policy in place to address disconnecting from work. We'll talk a little bit more about what that means. Implementation deadline, it's June 1st, 2022, which is 6 months from royal assent. So if you have 25 or more employees as of January 1st of this year, you've got to get moving on creating this, this policy. After that, so if you don't have 25 employees as of January 1st, 2022, you don't have to do anything now, but if you reach that threshold on January 1st, 2023, then you need to implement that policy by March 1st. So what does this policy looking for? What does it require? So first of all, what does disconnecting from work mean? So according to legislation, it means not engaging in work-related communications, including emails, telephone calls, video calls, or the sending or reviewing of other messages so as to be free from the performance of work. Now, as we'll talk about, one of the misconceptions with this legislative change is what right is this creating for employees? Great deal of confusion about that when the bill was first introduced. And then fortunately, the Ministry of Labor released some policy clarifications on this. And what they said is, look, we're not creating a new disconnect from work right. The Employment Standards Act actually already contains those rights through the hours of work provision. So we have maximum hours of work provisions, overtime provisions, and that is where the disconnect from work policy is contained. So the Ministry of Labor's position is that we're not creating a new disconnect from work right. What we are doing is creating an obligation on employers to create a policy that defines and outlines what their expectations are for disconnecting from work. So in terms of the policy requirements, and this is right in the legislation, it has to be dated. If you make changes for that, you've got to reflect those changes as well. Employees have to be provided the policy within 30 days of its creation or amendment. If you're hiring new employees, you have to provide it to them within 30 days of hiring. And then there's retention rules. So these policies and any revisions have to be retained for at least 3 years after expiry. So again, as noted, the Ministry of Labor or the ESA doesn't mandate the content of the policy. It's leaving that up to employers. And as I noted, the right to disconnect would be established in other sections of the ESA. Doesn't have to be a standalone policy. Many of you probably already have handbooks describing your workplace policies. So this disconnect from work policy can simply be a new section in that. So what should these policies look like then? Well, I can tell you what I've been doing for my clients. So what we've been doing is creating expectations around response times. So for my clients, they wanted to be clear that they didn't have an expectation of responding to communications after hours. So it's not necessarily 9 to 5, it's whatever that individual employee or your employee's schedule is. So for my employers, what they're saying is look, if you get an email after hours, there is no expectation for you to review it or to respond to it until you're expected to be performing work the following day. Certain communications may require a response, and the policies can identify that. So if you have a continuous operation that's highly safety sensitive, communications about an accident in the workplace have to be responded to. So that may be something that could require a response by specific employees. Similarly, identifying situations where a response may be required, emergencies, urgent situations involving clients or customers, that sort of thing. Some of my clients are using out of office notifications and voicemail message to indicate that they will not be responding to communications outside of their expected business hours. And then finally, identifying specific employees that may be responsible for responding, whether that be person in charge of health and safety or other management staff. So that's the ESA changes around the disconnect from work policy. If you want more guidance, I don't have the link here, but I can provide it to you if you reach out. The Ministry of Labor's website has some very good information about the disconnect from work policy, the content that goes into it, and specifically the parameters around it. So I would encourage you to seek that out. Most importantly for now, remember, if you have 25 or more employees, the deadline is June 1st to implement that. So moving on then to the second significant change with Bill 27 and to the Employment Standards Act involving non-compete agreements. So a bit of context and history first before we look into this. It's always been the case, ever since I started practicing in 2004, that courts do not like non-compete agreements. And we live in a democracy, we live in a free economy. We believe that competition amongst businesses is healthy for our economy. So courts don't like restraining employees from competing against businesses. More importantly, employees need to work. So we should have the right, if a better opportunity presents itself or if things aren't working out, to go out and seek another job where our skills are best suited. And oftentimes our skills are best suited for a competitive entity. So courts have never liked them, and they've always said that a non-compete agreement will not be enforced except in very unusual circumstances. Right? So if the employee is very senior, if they're classified as what's called a fiduciary, if they could create great harm to the organization, and if the duration of the non-compete is very limited, then yes, maybe we can enforce that. But for the most part, we're not going to allow them. That didn't stop employers, though, from introducing non-compete agreements into their employment contracts. And a lot of times the reason is simply to have some sort of deterrent effect, right? So they said, look, I get it. I understand that my non-compete may not be enforceable, but I want to put it in there anyways. And that's the big change that comes with Bill 27, because we can no longer do that. So under a new section 67.2, no employer shall enter into an agreement, into an employment contract or other agreement with an employee that is or that includes a non-compete agreement. What is a non-compete agreement? It's an agreement between an employer and an employee that prohibits the employee from engaging in any business, work, occupation, profession, project, or other activity that is in competition with the employer's business. And this is critical, after the employment relationship between the employee and the employer ends. Afterwards. So there is nothing inappropriate about saying to an employee, you cannot compete with me while I'm employing you. That's a very serious breach of the employment contract. And these changes don't affect that right of an employer to say, can't compete with me. The ESA creates a couple of exceptions. So number one, where there's been a sale of business, and the seller of that business then becomes an employee of the purchaser to sort of oversee the transition of the business to new ownership. We see that often, right? A business is sold and the owner is the face of that business, and it's necessary for them to continue on with the purchaser to ensure some degree of continuity. So that's an exception that's been created. And then secondly, executives, and these are very specifically defined as C-suite officers. So your CEO, CFO, chief legal officer, chief human resources officer, those types of individuals, we can have non-compete restrictions for. So what are the limitations then? So number one, it does not apply to non-solicitation agreements. Those are valid. So sometimes we get confused about what the difference is between a non-compete and a non-solicitation agreement is. A non-compete agreement is a blanket, thou shall not engage in work that's competitive with your employer. Right? A non-solicitation agreement is very different. It means that after the employment relationship ends, you're not going to go to a competitive entity and start poaching employees, clients, suppliers. We can still do those, provided that the non-solicitation restriction is reasonable in its scope and nature. So going back to my initial point about courts not liking non-compete agreements, what they've said is that a non-solicitation agreement is okay, provided that it's reasonable. So if you have a non-solicitation agreement that is permanent or lasts for an unduly long period of time, like 10 years or something like that, that's going to be struck down. But if you have a non-solicitation agreement that is time limited, say 6 months to a year, it's limited in geographical scope, then the courts have said that's a reasonable way of protecting your business. And there's nothing in Bill 27 that restricts the ability of employers to do that. Secondly, and very importantly, non-compete is not the same thing as having a confidentiality and proprietary information agreement. So in any employment relationship, it is implied that when the employment relationship ends, and frankly, during the employment relationship, the employee is not going to use the employer's confidential and proprietary information in order to compete with it. Right? That's implied, but it's always a good idea as an employer to have that agreement in writing so that it specifically outlines what the employer considers to be confidential. Now, we did have an early decision on the non-compete restriction in 22 concerning a dentist, and the court in that case said this non-compete restriction doesn't apply retroactively. So if there are non-compete agreements that are in existence prior to when Bill 27 came into effect, they're not necessarily invalid, or they're not automatically invalid because of this new non-compete restriction. So as a result, in those cases, in pre-existing non-compete agreements, we have to look at what the common law says, or what judges will say about the non-compete restriction, and we have to look at their reasonableness. So this blanket prohibition that's now in the ESA with respect to non-competes only applies with respect to any agreements after December 2021. So let's then talk about the practical impact about this. Number one, is this really just much ado about nothing? Because as I mentioned, it's always been the case that non-compete agreements have been invalid. And so the talk amongst employment lawyers when this bill was introduced was this was more just a political ploy, sort of vote pandering by the current government to try and show that they're doing something to protect employees. And perhaps there's something to that, given that non-compete agreements have never been considered valid except in very unusual circumstances. So it doesn't really represent a fundamental change in the law. But as I mentioned at the outset, what it does prevent is employers using non-compete agreements as leverage. Because as long as there's no legislation, or it's not written into the Employment Standards Act that non-competes are banned or invalid, employers, as I mentioned, are going to use them as leverage. And they're going to say, just stick it in there anyways. Maybe it's enough to scare the employee. And if we do have an issue, we can always say that a court's going to enforce it, and then we'll deal with it later. I don't think that employers can do that anymore. They don't have a basis to do that unless we're talking about a C-suite officer. So in that respect, one of the interesting practical impacts is because the ESA now carves out an exception for executives, does that now give employers a stronger grounds or license to introduce non-compete agreements for C-suite officers. Because we always had the argument for C-suite officers that the non-compete was invalid, right, because of the common law rule, and we still have that argument. But what I can see now is employers saying, hey, listen, that non-compete with respect to our CFO is valid because the Employment Standards Act specifically says that we can do it, right? I don't think it quite goes that far, but I think I think we're going to see that type of argument from employers. So in terms of other changes, and those are the major ones and the ones that were really causing a great deal of confusion. So I mentioned there's a licensing requirement for temporary help agencies or recruiters. So agencies or recruiters cannot operate now without a license from the Ministry of Labor. If they do, they could be subject to fines. I mentioned the changes to the Occupational Health and Safety Act. So workplaces now have to provide bathroom access for delivery persons, subject to very specific exceptions. So if it's unsafe to do so or impractical to do so, the employer may be exempted from that requirement. The Workplace Safety and Insurance Act was amended as well with respect to the distribution of excess insurance funds. Some complicated changes that I don't have a lot of time to get into now, but if that's something that you're interested in, it's definitely something to look into. Moving on then to Bill 88, introduced earlier this year. That came into force very recently, April 11th, 2022. Key changes requiring a policy on electronic monitoring, creating a digital platform for workers' rights, the Workers' Rights Act 2022, and some other ancillary changes. So in terms of electronic monitoring, similar to Bill 27, the right to disconnect, it applies to workplaces with 25 or more employees. And so employers have to implement a policy with respect to electronic monitoring, if that's what they're doing. So if you're GPS monitoring delivery trucks, if you're monitoring emails or internet usage, we have to tell employees, and we have to mention that in a policy. The deadline of October 11th, 2023 to create that policy. And then similar to the disconnect policy, an annual deadline of March 1st if the employer has 25 or more employees on January 1st. So in terms of the content, not a lot of guidance yet, but I expect that that's going to come out. Policies must advise employees whether they're being monitored, the circumstances of monitoring, and then how information collected will be used. So an interesting change, and one that we've been struggling with for some time to some extent. What we've always advised employers is if you have a policy that describes your right to monitor, and it informs employees that they are using the employer's property and that they should have no expectation of privacy, then they can do that. The problem happens for employers that don't say anything, that don't have a policy at all, and take the position that they automatically have the right to monitor by looking at email messages. And so the courts have said, no, that's not the case. If you have allowed your employees to use your IT equipment for personal use, you have then created a reasonable expectation of privacy around those communications. And so it wouldn't be fair for you to go in and snoop around and find information that could be prejudicial to those employees. So now the law is just making that clear. If you're going to engage in this monitoring activity, then you need to have that policy in place. But again, for the reasons I just talked about, if you have less than 25 employees, still a good idea to have a monitoring policy. Digital platform for workers' rights 2022. This one's still in place, so it's unclear when it's going to come into force. What we do know is that it's applicable to digital platform workers, including rideshare, delivery, and courier services. And the intention behind this legislation is really to create minimum standards around minimum wages, entitlements to tips, having recurring pay periods, anti-reprisal provisions, dispute resolution provisions, and providing notice that the worker is going to be removed from the digital platform. So we're effectively creating an ESA-like statute to protect these individuals that have proven to be vulnerable, right? Because for the most part, they're not employees or independent contractors, but they are vulnerable in many of the same ways that employees are vulnerable. So our legislature has deemed it fit to create this legislation to create some minimum standards with respect to them. All right, and then just very briefly, some other significant changes. Effective January 1st, 2023, business and IT consultants are excluded from the ESA. Reservist leave, which I've never had to deal with, has been extended, reduced to 3 months from 6 months. And some significant changes to the Occupational Health and Safety Act effective July 1st. So a maximum fine of $500,000 for individuals, a new penalty for failure to comply with orders, which would be $1.5 million for corporations, or 12 months imprisonment. And there's specific aggravating factors that a court can look at to determine what type of penalty should be applied and whether or not it should approach the maximum. Previously, for prosecutions, it was a limitation period of 1 year. That's been extended to 2 years now. And now, in recognition of this ongoing opioid crisis, there's a requirement for workplaces to have naloxone kits where there is a risk of opioid overdose in the workplace. All right, and that's actually all that I have. And I can open it up now to you for questions. And by the way, I'm happy to provide my slides. My contact information is right there. So if you want a copy of the slides, if you want to connect with us directly, just feel free to send us an email, and we'd be happy to send you a copy of the slides.
Wonderful. Thank you so much, Rishi. There was a lot of great information there. I'm sure everybody's head is spinning at this point in time. I think I do have one question in the chat from Tori. Tori, did you want to ask your question, or do you want me to just read it out for you?
I can ask it.
Okay, great.
So Rishi, I work at Gordon Food Service. So we are a 24/7 operation. We have a lot of night shift employees, obviously. That's where a majority of our business is happening. And so we just making sure that the bill with the expectations of replying to things after work, that doesn't restrict us from sending messaging to somebody outside of their regular hours. It just puts guidance around us, expecting them to respond to us when they're not at work.
Exactly. Okay. Exactly. You know, every operation in business is unique, right? So you need to define what your expectations are and put it in writing and communicate that. That's all.
Yeah.
So I think it's entirely fair to say you may get a communication, but we have no expectation of you reading it, reviewing it, or responding to it. And in fact, we encourage you to use an out-of-office notification, or perhaps even turn off your phone at the end of your day.
Got it. So it's more just around restricting, like disciplining somebody, for example, if they don't respond to something when they're not at work, right?
Yeah, for sure. And you know, I think arguably, you know, that right already existed, right? So if someone had a shift and it was over, you know, they could say, you're expecting me to respond. That's a form of work. You shouldn't be doing that. That's contrary to the ESA. So this is more about just communicating in writing what disconnecting from work looks like in your workplace.
Great. Thank you.
You're welcome.
right, do we have any other questions? Craig, did you want to ask your question or do you want me to read it out for you?
I can ask it.
Wonderful.
Can you hear me? Yeah.
Yep, we can.
Okay, so I just have a simple question. I mean, it's in the chat there, Rishi, but so a customer needs some very brief piece of information. It's a 1-minute phone call. I just chose 1 minute as a simple example. I read an article in the media a few months ago when this first came out that, oh, this means you have to pay them a minimum 3 hours wage for whether it's one phone call or 1-minute phone call or 30 minutes or an hour or what have you. Or do they just need to be told, hey, part of your job is once in a while, you got to take a call after hours? Any color on that would be great. Thanks.
Sure. Yeah, the 3-hour rule, I'd have to take a look at that in the ESA to see specifically when that applies. You know, I've never heard of a situation of that happening, right? Where that call needs to be taken. I mean, I do think there's an issue there with disconnecting from work, right? If someone has scheduled hours, and they're required to respond after hours, I think that there is probably an issue there around compensation, but I don't know that the 3-hour rule applies. I think that's something where we would have to look more specifically at that situation and see what works.
Okay.
Right? On the other hand, if you've got an employee like a sales employee or something like that, they're paid on a commission basis or they're paid a fixed salary, and your employment contract very clearly defines that, you know, they don't have any fixed hours of work, maybe they're excluded from overtime requirements, then I think that's something that you to consider as well, and maybe the strongest defense that you have, right? It really comes down to how you've defined that employment relationship, what the position is, what the contract says, and whether or not there's any exceptions from the ESA.
Okay, thank you. And I got one more, if I may, unless you got others queued up. Okay, the second one is on the fines that you mentioned at the end. So I know it's early and maybe there haven't been that many violations to, I guess the deadline's not even there yet, so we don't, you may not know.
Right.
But is this going to be, oh, it turns out you have 26 employees, you miscounted. So you're in violation, you owe us $1.5 million, or you're spending a year in jail, or is there going to be a warning? Hey, you have 30 days to comply, and then so on and so on. How do you expect that will work?
Sorry if it wasn't clear. Those changes apply solely to the Occupational Health and Safety Act, so not the Employment Standards Act. So this would be in the case of very serious workplace safety issues. Right, so an accident on the job, something like that, or, you know, the Ministry of Labor comes in to inspect, issues an order surrounding safety, and the employer sort of flagrantly continues to ignore those orders.
Okay.
Right,
okay.
that's where that's going to apply, right?
Okay.
You know, and it's sort of incidentally, employees and employers have paid significant fines, and some of them have gone to jail, right, because of health and safety infractions, right? And so that's really what this is after. It's about health and safety. Now, under the Employment Standards Act, there is the possibility of prosecution and significant fines and jail time. People have spent time in jail, but that's reserved for the failure to pay wages, right? So there's been situations where employers have simply refused to pay student wages, right? I remember there was a situation with a pool contractor. He would hire students, they would work the summer. He refused to pay them any vacation pay, any accrued wages, ignored orders. And that unfortunate gentleman had to spend time in jail. So those are the types of situations where jail time or significant fines might be applicable. But not stuff like this. Not we didn't implement the policy on time. I think with respect to that, what we're likely to see is just a compliance order.
Thank you.
Pleasure. Great questions.
All right, does anyone else have any other questions? If you want to put your hand up, you can use the reactions key at the bottom, or you can type your comment. what came to mind a little bit to me, oh, we've got Hillary. Hillary, go ahead.
Thanks. Just a simple question. Could you just clarify in simple terms the distinction between non-solicitation and non-compete again?
Sure. Yeah, absolutely. So non-compete is when the employment relationship ends, you will not work for our competitor for a period of 1 year. Right? That's a non-compete. Right? Non-solicit is after the employment ends, you will not solicit or offer business to our clients for the purpose of doing work for a competitor.
Okay, so the non-solicitation is still valid, but non-compete is not.
Yes, yes. Depending on how the non-solicitation clause is drafted and the duration of it, and other requirements around reasonableness.
Okay, thank you.
You're welcome.
All right, I'm just going to scroll through and see if I've got any other questions, if I can see any hands up. Okay, something that came, Craig. Yes, go ahead, Craig.
Yep. All right, so I'll just get my video on here. But we do, like, similar to the other Craig's question about we do have flexible work hours too. We kind of do environmental consulting work. So sometimes staff may come in, at like super earlier in the morning to dodge that heat in the middle of the day. And we do have kind of like a flexible kind of work policy. So do you know how that would work with, like if someone decided to work a bit later that day versus earlier, would there be any issues with that, like working outside of work hours kind of thing, if they decide to work later that day?
I guess my first question would be if they're excluded from the hours of work provisions from the ESA, right? That would be my first question, and if so, then I don't think that there's any issue with that.
Okay.
So as an example, if you've got a manager, operations manager, they're excluded from the hours of work provisions, right? So there's no issue with that at all. If they're not excluded, then there may be a potential issue about the amount of work that they're doing, right? So if they're crossing the overtime threshold, that could be an issue, or if they're working in excess of 10 hours a day or 48 hours in a week, then that might be an issue. So what we'd want to do is take a deeper dive at your operation, the employees, the jobs that they're doing, and whether or not they're covered by the ESA.
Okay, no, thank you.
Thanks for the question.
All right, I'll check to see if there are any other questions. And if you do think of something else, you can definitely email Rishi and ask your question. And if something comes up later on today, it just pops into your head. And I just want to make you aware that Rishi has generously offered a 30-minute free consultation as well for all of our chamber members. So if you'd like to connect with Rishi, you can reach out to him at info@blpc.ca. He will provide that contact info in the email, the follow-up email that we're going to send along with the slides. And I see Nagme, you have got a question. Go ahead, Nagme. Just unmute yourself first.
That's a good idea.
There we go.
Hi, everyone. Okay, first of all, thank you so much for this webinar. It's been very helpful. And then the next order of business I wanted to talk to you about was, I was going to ask you, we have a tutoring center. So we are in Oxford Learning. We have a school during the day. So we have our full-time employees, and then we've got tutoring in the evening. I was wondering, what is the minimum amount of hours I can book an employee for part-time work in a day?
Minimum hours of part-time work in a day.
Yes. Or is there any rule again around that?
There may be. I'd have to take a closer look at the ESA.
Okay.
There is a 3-hour rule. But I think that that may only apply if they're called in for a longer shift and then sent home early. I'd have to
Okay,
double check. I haven't looked at that in a while.
right.
But my first reaction would be, I don't think that there's a minimum requirement for part-time work. There's nothing in the ESA that defines part-time work is X and shall be a minimum of so many hours up to a maximum of so many hours.
Okay, perfect. I'm so happy to hear that because usually, obviously, I don't like to book only 1 hour for a teacher because it's just out of the way, and they come all the way and then they just teach 1 hour and leave. It's not right. Usually I do at least a minimum of 2, but that's the least I could, like, that's the best that I could do, because sometimes it's just there's not a lot of.
Yeah. And practically, you may have a retention issue with that too, right? Because nobody wants to drive across the city to do an hour or 2 of work and then leave, right?
Exactly. So those things does happen just because of the situation. Yes, that's why I always try to give them 2 hours minimum. Okay, thank you very much for answering that.
My pleasure. And I dropped my email address in the chat box there too. So you can by all means email at info@blpc or send me an email as well, or send it to both.
Wonderful. And then Rishi, I had a question for you about the monitoring. You had said that they can monitor emails and whatnot. They just have to disclose it. Does that extend to social media as well? Like if you're in a company that maybe has different views or whatnot, does that, then you have a different view and you're posting on your social media, is there a right for the company to monitor that and say, hey, take that post down, or where does the line draw?
Yeah, that's a great question, right? And I think the distinction with social media and other electronic monitoring is when you go on social media, you're putting that stuff out there for the world, right? It's publicly accessible. So I don't think that there's any restriction against the employer going on to an employee's social media and seeing what they're putting out there, right? And so what's becoming an increasingly important issue is the scope of allowable off-duty conduct. At what point in time is an employee's off-duty activities prejudicial to the employer, and when can they take action against that? Right? I had a very interesting issue last week arise. I won't get into the nitty-gritty details, but someone had sent an accidental text message to an employee, and there was some very salacious things in that text message, right? Needless to say, it wasn't intended for that person, and that person was shocked by it and made a complaint about it. And so that's what the employer is dealing with. Is it harassment? Is it misconduct? You know, clearly this employee is engaging in some sort of off-duty conduct that's not that may be morally objectionable, but it's their life outside of work. So what can we do about that, right? So increasingly we're dealing with that issue. And so I think really the issue is, you know, sure, you can look on social media, you can see what they're up to, but what sort of action can you take in respect of that off-duty conduct? I think if the employee is disparaging the employer, their products, their services, their personnel, that is definitely actionable. But I think where the gray area comes in is if the employee is, you know, has certain political views, is, you know, supports Donald Trump, or, you know, supports these protests in Ottawa, and if that's not consistent with the employer's views, what can they do about that? That's a trickier issue for sure.
And I guess also too, it's tricky when you have a company phone and you're using it for personal use as well. I know quite a few of contractors, construction workers, stuff like that, roofers, they have company phones. So they've got rid of their personal and using company phone for personal as well. And, you know, as you said about the text and whatnot, where does the line go on that?
And this is where the lines are
interesting
blurred,
things,
right? The line between our personal life and our professional life is completely blurred. Right. And what our courts have said is that look, just because you own that phone doesn't give you a license or a right to go into it and look at everything that they're doing, right? If you've given them that phone and then for 5 years, you've never done anything and then they just decide to go in, that's not fair, right?
Okay. All right, I think we have exhausted all of our questions. Once again, Rishi, I want to thank you so much for sharing your expertise with us. Lots and lots to think about, lots of things popping into my head as well. So, I might be taking you up on that 30-minute free consultation as well. And so in closing, I just want to go over some of the great events that the Chamber's got coming up. We are doing a huge celebration of our welcome back from hibernation barbecue. Woo woo! Being able to be in person. It's a live event over at the fairgrounds. It's happening next Wednesday, I think. Yeah, Wednesday, May the 18th from 4:30 to 6 p.m. At the fairgrounds. We also have our body language for business, understanding the fundamentals and reading your influence. Right, that's happening on May 26th from 4 to 6 p.m. We have our business before basketball. So if we've got any sports fans out there, we've partnered with the Hamilton Honey Badgers for their home opener on May the 25th. It's from 5 to 9 p.m. There's networking opportunity, and then you'll have the opportunity to watch the basketball game as well. In June, we do have our golf tournament coming up, so please register yourself for your foursomes as well. And the Incredible Race 2 is happening June 22nd. And if you want to put in a team, a company team, it's great for team building skills and just having a little bit of fun and networking as well. Again, Rishi, thank you so much for your presentation. We will be emailing out the slide presentation and maybe that link that you mentioned too, Rishi. If you do find that, we can include that in the email. And have a wonderful day. Oh, and for Live at Lunch as well, if I do have any members who would like to share their expertise through a webinar, I am booking for the rest of the year. So please get in touch with me at sales@miltonchamber.ca and we'll get you scheduled in to share your knowledge with the group as well. All right. Thank you so much, everyone, and have a wonderful day.